Good afternoon, everyone. Thanks for joining us. So today, Sarah and I are going to be talking to you about what's been going on in family court. What are some new updates? What's happened during COVID? What's left over from COVID, and what we can expect going forward this year. So first, during COVID, we experienced the new virtual appearances and the virtual proceedings, and those look like they are here to stay for quite a while. So the way that works is the court will issue a Microsoft Teams invitation. You do not need to have Microsoft Teams. You do not need to have an Outlook account. They'll provide you a link. If the link for some reason does not work for you, they also provide you a dial-in number, but do try to click on that link, try to get that video going because the courts want to see you and we want them to see you. We want them to see your body language, your facial expressions. That's important in this proceeding because they are looking to see if you're credible in your position, if you are a truth teller, and your body language is going to be able to let them know that you are. And so you do want to try to get on that video. But if, technical difficulty happens, as they do, then there is always a backup call-in number and you can participate over the phone. Most of the proceedings are virtual. There are a few exceptions, and we'll get into that a little bit later. You're also going to need to have an email address. You are going to be receiving documents from the court via email. That might include a summons, it might include an order. And so you are going to want to make sure that you're paying attention to your emails and that you are aware of any emails that you may get from the court. Also from us, from your attorney, or if you are a self-represented party, then you may be getting emails from opposing counsel or the attorney for the child. So you want to make sure that you have an active email that you are consistently checking so that you don't miss anything, because what's not happening is they're not sending paper backups. You may just get that email, and if you miss it, you could miss a court date or you could miss an important communication, and that could damage your case in some way. In family court, we are dealing with special proceedings for a certain types of cases only. So these are going to be your custody cases. Whether or not you and the other parent of your children have been married or not, you can engage in a custody proceeding in family court. That also includes parenting time. If you're seeking out parenting time, then this is the venue for you. Every county has their own family court, and so wherever you are residing, or if the child resides with you, or if the child resides in another county, that's where you're looking to start your proceeding. We also do child support and spousal support proceedings in family court. Those may be with a magistrate, but it's still under that family court umbrella. Family offense and petitions or orders of protection, you're going to see that in family court as well. Now, this is going to be different from any criminal order of protection that you may have experience with. This is really limited to you having a familial relationship with someone, and that is defined in the statute. And if you are unsure if you have a familial relationship with someone, you're going to want to speak to an attorney or do some research to make sure you're in the proper venue if you're seeking an order of protection. Also, neglect, abuse, and Article 10 cases. Those are cases that the Department of Social Services through CPS may bring against a parent if they believe that neglect or abuse exists. That could be educational neglect, medical neglect, or abuse of any kind. Those also fall within the family court special proceedings. And then, of course, we have our juvenile proceedings under Article 3 and our PINS proceedings under Article 7. PINS stands for Persons in Need of Services. If you have a youth that you have custody of and you're really struggling with them, if they're, say, not going to school or if they're running away, this is an avenue for you to get some relief through the court system. And so it's something that I want to make sure we touched on today so people know that there is some relief out there if you are in a situation like that. And now Sarah is going to walk us through some of the petitions we can bring in family court.
So in family court, of those proceedings that Leslie just mentioned, I'm going to focus on 3 common proceedings, which are custody, support, and family offense. So with custody, there's typically 3 types of petitions. A de novo petition, which means anew, meaning if you don't have a previous order of custody or a judgment of divorce, you're starting afresh. So you're filing for custody. It would just be called a petition for custody. The next one is a modification petition. That's if you're looking to modify a current order, whether it be an order of custody from family court or a judgment of divorce from Supreme Court. Typically, for modifications, judges would like if you wait at least a year before you try to modify it, unless something serious happens. There's like a serious new concern of abuse or something along that nature. The third type is enforcement or violation petitions. That's if the other parent or other party to an order is violating the terms of the order. For instance, if they're supposed to have supervised visits and they're not having supervised visits, they're, not with the supervisor during their parenting time, or, one party or one parent is not allowing access to the other parent. So you file a petition trying to enforce the order, saying, "Oh, I'm supposed to have parenting time every weekend, and I'm not getting the child." Typically, you would get makeup time if you were successful under that sort of petition. The next proceeding would be support. Same kind of idea as custody, where it'd be a de novo petition if you didn't have a previous order of support or judgment of divorce. And you could be seeking child support or spousal support. I don't think I mentioned this earlier, but for a de novo petition in support and in custody, you would have to have the birth certificate, or at least you should have it. It's good if you produce it. So the next type of support would be modification. If you are seeking, an upward modification of support, whether it be spousal or child support, that's under your current order. Typically, there are 3 ways that you can be filing for a modification of a support order, which is there's been a substantial change in circumstances since the previous order, 3 years have passed, or there's been an increase in either party's income by 15%. Another modification that you could be requesting is if the current order has the payor paying directly, and you're modifying it, requesting the court to have the order be through support collections unit. So you don't have to follow up with, say you're receiving support from the father. You don't have to follow up with them every week when you're supposed to get it. Support collections is an agency that will handle it. The next type of petition is an enforcement petition or violation petition. If the payor is not paying their support or not reimbursing for expenses that they're supposed to be contributing to. We also have termination on here. This termination petition is, support orders typically don't self-terminate. If you're not paying through support collections, you can simply stop paying. There is a chance that you could, be in violation if you're supposed to still be paying. But if for termination, for instance, if the child's 21, because in New York, child support's paid until the child is 21, you'd have to file to terminate the order of support or the judgment of divorce, the terms relating to support and the judgment of divorce, in order for support to stop coming out of your paychecks or however it is being taken out. The third type is family offense. This is for when you're seeking an order of protection. For these types of petitions, it's important to bring any police reports that you may have filed. And there's 3 types of petitions. There's an emergency one, and it's called an order to show cause. And it's a motion, so you'll file the order to show cause with a emergency family offense petition. With that, a judge could issue an order of protection, a temporary one, ex parte, meaning without the other party present. And if that does get issued, an appearance typically will be scheduled for the other party within like a week. The second one is an enforcement or violation. If a party has, violated the terms of an order of protection that's already been issued, whether it be criminal or a family court order of protection. For instance, if there's a full stay away order of protection, meaning there's no communication, you're not allowed to, the other party's not allowed to show up at your school or at work or at your house, and they do, you can file a petition saying they're violating this. There's also a type, a modification. I didn't have that listed in the slide, but if you have a order of protection that's a refrain from, meaning the party that the order of protection is against can still talk to you, can see you, but they do something that's illegal, harassing or assault you, you could file a petition requesting the court modify the order of protection and seeking a more restrictive order of protection, like a full stay away. So let's see. The next part I want to talk about is the timeline of a proceeding. How they all start, you file your petition, or your attorney files a petition, and it's scheduled for a first appearance. As Leslie said earlier, the first appearance these days are typically virtual. Some courts with family offense petitions, when there's an order of protection issued, they do like the parties to appear in person. Or if you're in Saratoga County, in this area, both Judge Nussman and Judge Pelagali have all the appearances in person. So at the first appearance, what happens is the respondent to the petition is arraigned on the petition. Basically, the court asks, did you receive it? How do you respond to it? Usually there's an enter of a general denial. It's really just to, discuss the basics of what's going on and if a temporary order needs to be issued. The next appearance would be called a further proceedings. There could be a few further proceedings. And typically during this time, if there are attorneys, if you have an attorney and the respondent has an attorney, between the first appearance and the following appearance, the further proceedings, negotiations are going on, and the judge is really hoping that, the parties can resolve it without, going to trial. So there could be a few further proceedings because when we appear, you could tell the court, oh, we need a little bit more time, or we want to see how things are going. But if it's clear as things proceed that you're not going to resolve it, the matter will be scheduled for a pretrial and a trial. At a pretrial, it's typically more of a procedural appearance. The judge will let the attorneys know, or the parties know, when witness lists are due and exhibit lists are due, and exchange of it. Pretrials also can be treated as a settlement conference, where the judge's court attorney will meet with all the parties and the attorneys and try to resolve it right before a trial. And then the next, if not resolved, it will go to trial. And majority of the courts, the family courts in this area, will like trial in person. When COVID, first hit in the months following, most of the trials were virtual, but it seems nowadays a lot of them are in person. So the next thing is the commencement. How do you commence a proceeding? Like I discussed before, there's a petition that needs to be filed. And unlike Supreme Court and family court, there are no filing fees. Anyone can file a petition for free. And after COVID, the electronic filing became more of a thing, and it's called EDDS. I forget exactly what it stands for, but it's electronic document something service. I forget. But
Delivery system. Delivery
system. Yes. And that makes things so much easier. You can file your petitions right online directly to the court. The court receives it, immediately. Whether they process it that day is a little different, but I've discussed a couple of times with clerks, and they love EDDS. But however, they still allow in-person filing. So if you want to go down to the court in person and file it, that's still a thing. Each county kind of does it differently. your miles may vary. I know in Albany court, you don't ever speak directly with the clerk face to face. There's like a screen up, you scan it into a computer. So in Saratoga, you can literally hand it to the clerk. So it's straightforward, but most of the filings now are online. And so once you file that petition, once a petition is filed, what happens is a summons is issued. And the summons will provide the date, time, and location of appearance for the first appearance. So location is important these days because it used to be just the court. And now it will say if it's in person or virtual through Microsoft Teams. It will list the judge, who will you be appearing before. Typically for family offense petitions, when there's an order of protection issued, it's delivered to the respondent via personal service by like a police officer will try to personally serve the respondent. Otherwise, it's done through the mail or email if there's one provided. I do believe non-represented respondents get email and mail for the service of the summons. Next, Leslie and I are going to be talking about the pros and cons of virtual versus in-person appearances.
So one of the things that Sarah and I were discussing as we were putting this presentation together is how we enjoy virtual appearances. We as attorneys really find that, number one, it's a big cost saver for our clients, and their resources can go a lot further. These virtual appearances will last somewhere between 15 and 30 minutes on average. Sometimes they are longer if you're dealing with a more complex issue. Sometimes they're shorter if you are just, meeting with the court quickly on a status update. And, that really saves on having to go down to the courthouse, especially if we're going to Albany, and the parking can be challenging. Not every courthouse has a parking lot. And so being able to just log on from our office and address the issue with the court, and then speak with our clients, and then move on to another issue, it also helps productivity on our end. There's no delay, and it really helps the case move along. You also can get some more of the court's time because you're not using up so much of it. So if you need a conference with the court, they're more likely to schedule it with you because these virtual appearances really do run smooth and can move the case towards resolution. But there are some drawbacks to the virtual appearances. And Sarah, do you want to touch on some of that?
Yep, definitely. So I think one of the main advantages of being in person was having all the parties there together. I feel like a lot would get done in the 10 minutes before a court. You would have, a 4-way or 5-way conference with all parties, attorneys, the attorney for the children, and you could get a lot done. Now it's so separated. Most of the time, attorneys and their clients aren't together. So it's through phone calls like you would through just normal negotiation. Another, I believe, disadvantage is in the actual court appearance. When in person, your client was sitting right on the side of you, so you'd whisper, you could talk. It was easier to communicate during the proceeding. Now, if it's virtual and you're not with your client, you're calling them, or if something's happening with their IT and their Wi-Fi is not good, they can't really follow. It's a little bit of a mess in that sense, but it's good and bad. Do you have any other negatives?
No, I do agree. You have to put in that effort to communicate before the appearance, and some people get so comfortable with the team's invitations holding that place in their calendar that if it doesn't come out until the day before or the day of, you have to make sure that you're planning in advance and that you're making time to speak with opposing counsel or with the attorney for the child. So there is some organization that's required on the attorney's end or pro se party's end.
Yeah.
And I agree with Sarah. A lot of cases resolve on the courthouse steps, and that is something that, unless you specifically request an in-person appearance or you are told to come in person, you might not be able to take advantage of. And that goes for, being in person for trial too.
Mhm.
there is definitely a benefit to being in the courthouse, to feeling the environment of the courthouse, to the seriousness of the proceeding, as well as some technical things. Sarah, how do you feel about, exhibits and objections and all of that, virtual versus in person?
Um, you know, it is a little bit more challenging virtual because you have to send everything ahead of time. You have to make sure everyone's computer and their access to like PDFs are working. If they're doing it on their phone, it's hard to look at exhibits and testify. I do think in virtual makes court a little bit more casual for parties, especially non-represented. Sometimes they're just appearing by phone. It's not the pressure or just being before the judge that you would have in person. But for trial, exhibits are a big one. Virtual. I mean, I don't want to say virtual is terrible. I mean, I've done a bunch of virtual trials and they're easy. It's just depending on the type of exhibits. I feel like now people will submit exhibits with multiple huge pages as opposed to before. It was more limited in scope. And another downfall with virtual is a delay. So if you have a party testifying, their Wi-Fi is not good, and they're skipping, or you can't really hear them, or it's blurry. That kind of affects their way that they appear to the court and before the judge. You don't get their full body language. It's just a little different.
I would agree. There's pros and cons on both sides, and it's really not up to us as to whether or not it's going to be virtual or in person. It's ultimately up to the court, and you prepare either way, and you're aware of some of the pitfalls that you might face, and you just have to prepare for them in advance.
I do think, though, on the flip side, if you are if your client is testifying, I've noticed they're a little bit more calm when it's virtual. So it could be used as a positive because you're sitting right next to them. You're in your own conference room with them, and they're not sitting at the witness stand next to the judge in the courtroom. Everyone's looking at them. It's just a little different in a positive way, virtual as well.
Good.
Oh, the next thing is attorneys for the child, or attorney for the children. We call them AFCs. And what they are court-appointed attorneys that represent the child or the children in the proceeding. And they are attorneys in the county that are part of a panel, and they are assigned by the judges for each case. And what their job is, what they're supposed to do, is represent the child's interests. It's a little easier when the child or the children are older and verbal, and they can tell you, yes, I want to live with dad, or mom's been saying this, or whatever. When they're younger, it's a little bit more difficult, but a lot of the good ones will be able to identify whether where the child's comfortable with, or if there's any safety concerns. And they're not assigned in every case. And actually, in some counties, you have to request one. It's not automatic, but in this area, they're typically automatically assigned in any family court proceeding involving a child. So the ones that I was discussing earlier, custody, a family offense, or what Leslie was saying, a PINS proceeding, they're not at all involved in support or anything dealing with financials. So there's no attorney for the child or children in a petition for child support. But they definitely carry a lot of weight on the custody side, family offense side, and family court. So it's a 3-attorney job when there's all attorneys for each party.
That's right. And while we're discussing some COVID rollover procedures, attorneys for the children really had a challenging time during the height of the pandemic in meeting with their clients. So they were doing virtual calls. I even spoke with some who would go stand outside of the house and talk through the door. And it was really tough for them to be able to ascertain the position of the child. But like Sarah said, when a child is of a certain age, it is a lot easier for them. And of course, if they're able to do virtual meetings with the child, the children sometimes are more adept at the technology than the attorney. And so they're able to express themselves pretty well on those virtual meetings with their attorney. Okay. Discovery in family court proceedings is not quite the same as in other cases. Because we're dealing with special proceedings, it is not always something that you're guaranteed to be able to get. It is very limited in its scope, and most of the time you need to either request it at an appearance and see if the other side will consent to it, or you're going to have to file a motion. When you file your motion, you are going to have to give some good reasons as to why you need discovery. If you're looking for mental health records, make sure you've made an allegation of a mental health issue, or else that's not going to be released to you. You also are going to be limited in the amount of time that you can go back and ask for documents. So if you have an order from June of 2020 and you're starting a new proceeding now, and you're seeking discovery, you can only go back to June of 2020. Anything that happened before that, you wouldn't be entitled to. You're not going to be able to relitigate what happened before. So it's very limited. If it's on consent, that's obviously a lot easier, but if that motion is required, again, just make sure your reasons are very clearly stated. Witnesses. Lots of folks come to us and say, you know, this happened and so saw it. Okay, great. But they have to come and testify in court to that. They cannot just write a statement. And this ties in with exhibits as well. So often there's, you know, maybe a grandparent that witnessed something and they want to provide a letter. The letter is great in the preliminary proceedings for counsel to understand what's going on, or for the attorney for the child to know what's going on. But you can't necessarily submit that as evidence in your case unless that person's going to testify to what they saw and then use this statement to corroborate their testimony. So you want to make sure, if you are collecting documents from folks, that they are also going to be able to testify. Sometimes in certain proceedings, we will have caseworkers that have to testify, and that's going to require judicial subpoena. So if there is some involvement of CPS, you want to make sure that your attorney is aware of that. And if you need a judicial subpoena, you need to watch your timeline, because you have to get that in by a certain amount of time before your hearing date so that you can get the subpoena issued, set up the caseworker to come and testify. Text messages. Everyone loves to send us their text messages, and they are very informative. You know, it's really that in the heat of the moment conversation, you know, what everybody's point of view is. But text messages are hearsay, and they have to, in order to be admitted, we have to make sure that we are within an exception, whether it's a party opponent, whether it's an excited utterance, whatever it might be. Present sense impression, meaning what they thought of during that, you know, that heat of the moment, what they said to you, if it was, you know, some sort of disparaging comment. Those text messages cannot be cherry picked. Don't just send me the good parts of the conversation where the other party said all the wrong things. We need to see the whole conversation, and so does the court. It can't just be one-sided. We don't want to see text messages that are cut off in the middle of the conversation. I want to see the whole conversation, and so will the court, so that they can really ascertain what happened. And also, just because someone is in your phone as John Smith doesn't necessarily mean that John Smith is texting you. So you also want to make sure that you have a screenshot of the contact information. We really want to see that phone number. And also, when you're screenshotting those text messages, just remember, if you want them to go to a judge, don't put any sort of foul language. Don't use any name calling when you are describing the contact. I've seen a number of inappropriate names for an opposing party, and I've simply said to my client, I cannot submit this to the court. You know, that's just not professional. So you want to make sure that you are, you know, keeping everything above board. Some cases, some custody cases will require a forensic evaluation. Right now, there is some back and forth as to whether or not forensics are still what's in the best interest of these cases, best interest of the child. What a forensic evaluation is it is a professional psychiatrist that meets with both parents and the children over the course of a few days and a number of different time frames, and they do testing. They will do psychological testing. They may suggest that one party has a diagnosis, and they are going to say how that diagnosis is going to impact their parenting. The number one thing that we are concerned with is, will each parent foster a relationship with the other parent during their time with the children? If they are not going to be able to do that, or if they are going to be able to do that, that's what we're looking for in this forensic evaluation. If someone, has a mental health disability and it's going to prevent them from doing that, it could come up in this forensic evaluation. So it's also important to be very clear and honest with your attorney and the court if you have a diagnosis, because it's not something to hide. It's something that you should put forth if you have been diagnosed, and that you, despite the diagnosis, you're still able to foster a relationship. If there are safety concerns within a custody proceeding, substance abuse concerns, those also can come out in the forensic evaluation. The cost of the evaluation is typically split three ways. Each parent and the child. The county will pay for the child's portion of it, and then each side should be paying for their own. However, if one party is appointed a public defender or a conflict defender, then they will likely have their portion paid for by the county as well. It's important to ask what the cost is beforehand. Some people like to run to a forensic evaluation because they believe the evaluator is going to be on their side. But let's make sure that the cost is worth it at the end of the day, because it could be, thousands of dollars just to have the evaluation prepared. And then you have to have the doctor testify at your hearing if you can't resolve. You can't just submit the evaluation as is. Again, we're going back to that firsthand knowledge. The doctor has to be there to testify to what's in that. When the forensic evaluations are done, they're submitted to the court, and the court will let the attorneys know that they have it. One of two things is going to happen. They are going to send it by secure email, sometimes with an order of protection saying that you cannot release this. Sometimes it doesn't have to be an order, depending on the acrimony in the case. I've had both recently this year. But the most important thing for an attorney is that your client cannot keep this forensic evaluation report. You can review it with them. You can tell them what it says, and you can tell them where the strengths and weaknesses lie, but you can't release it to them. You have to keep that safe in your file. Before COVID, they would tell us that the report was in, and you would go to the courthouse and you would read it there, and they would give you one copy for your file, and that would be it. So they really want to make sure that that health information, the mental health information, the information about the children, it's a very private document, and they want to keep it that way. So that's why they have all these protections around it.
I just want to say one thing.
Yeah.
For the evaluations, it's not just speaking with the parents or the parties, and their results from the test that the therapist or psychologist does. They also, some good forensics will meet with or speak with collateral contacts, so family members, or I've even seen one with employers, and you're allowed to ahead of time submit to the evaluator documentation that you want them to review ahead of time. So if there's a criminal history or orders of protection or something that you would like the evaluator to know before they do the evaluation, they will have the access to that, which I find is helpful, because a lot of people get worried, I'm not going to get everything out or during the evaluation. So at least ahead of time, they can send what they want the evaluator to know.
That's very true and very important. Yes, if you have documents, you definitely want to gather those. Okay. So if you've gotten this far in your case and you're unable to resolve it, now we're preparing for a hearing. Okay. So we touched on discovery. We touched on the exhibits and the text messages. Let's see here, the forensic evaluation, witnesses and testimony. If you have, as Sarah said before, the witnesses and exhibits, you are going to be given a timeline by the court when you should submit that. And if it's not given to you, you can certainly ask for it because you want to make sure that the court has that in advance. You want to make sure that you have exchanged those lists with the other side so that they can't object to any of your exhibits or your witnesses saying they didn't have enough notice. So you just wanted something to be aware of. Again, if you need to get any police reports or CPS records, those will need judicial subpoenas. So you want to make sure that you've talked with your attorney about the timeline on how to get those and make sure that you leave enough time for the judge to make a decision on that. Okay. Lincoln hearings. Lincoln hearings are the Lincoln hearing is when the child speaks to the judge, okay? And it's typically done at the end of the hearing. You can do it at any time. Well, some judges think you can do it at any time, though it is preferred within the case law that you do it at the end. The reason being is that any statements that are made regarding abuse or neglect of a child throughout the proceeding have to be corroborated by the child during the Lincoln hearing in order for the court to, really consider them with some weight. So you do want to wait until the end of the hearing so that you can make sure that the court has all the information before they go ahead and speak with the child. It is done in chambers with the child, with their attorney, and a court reporter. There will be a transcript. You as a party or you as an attorney will not get this transcript. If you have an appeal, that transcript would go directly to the appellate division. You are not supposed to receive that. I can say on a personal experience, I mistakenly received a Lincoln hearing transcript once. That is improper. It should never go to anyone except to the court and then to the appellate division if necessary. Lincoln hearings are mostly done in person. They may have had virtual ones during the height of COVID, but as Sarah and I are preparing for this, we could not find any cases that were doing virtual Lincoln hearings. A Lincoln hearing is not guaranteed, even if you request it. If the judge feels that it's not in the best interest of the child to put the child through the process of a Lincoln hearing, then they can deny it. And that's been upheld in the appellate division. So it's really up to the judge whether or not this is going to go forward. And that's something as parents that you need to consider. The age of the child, the advancement of the child, there's a case out there that had a child that had suffered from some special needs, and the judge said, no, I'm not putting the child through this Lincoln hearing, and that was upheld. So you want to make sure that before your child experiences this, that it's absolutely necessary for your case, and that's something you can discuss with your attorney. And you can also, the attorney for the child will also have a position on that as well. We also have a question in the chat. What are some situations where children are assigned an attorney? Whenever there is a contentious custody proceeding being brought before the court where the parents don't agree, the court will very likely appoint an attorney for the child. As Sarah mentioned before, it's not guaranteed in all counties. And that's something that we should say for everything we've discussed today. We're talking about mostly what we've experienced here in the Capital District, but we've had different experiences in other counties throughout the state. So in Albany and Saratoga and Rensselaer, you will get an attorney for the child appointed. In Schenectady as soon as your petition's filed, unless your petition says also enclosed herein is a stipulation and we agreed on everything. It's assumed that there is an issue between the parents and a position and representation for the child is needed. So you're going to expect that attorney for the child to be appointed. We have another question here. Can the child change his or her assigned attorney? It is very difficult to get an attorney for the child changed because you as the parent may conflict with the attorney for the child, but that may not necessarily be in the child's best interest. So before you go ahead and make that request, you definitely want to discuss the circumstances of your particular case with your attorney.
especially because if you gets denied, because it's, the attorneys, the AFCs are people, so requesting them to be removed and then they're not removed uh, isn't always the best outcome.
Right. It could result in you being more harshly viewed by the court in your case. Absolutely. Okay, we have one more question, and then we'll get to our final. Oh, we have two more questions. Then why don't we go to our final slide and then we'll go through the questions, or else we'll never hit it. Here we go. Okay, mistakes not to make. These are things that your attorney does not want you to do. If you do them, you'll make our job certainly much more difficult. Sarah, do you want to go through some of the standard terms that come out from the court?
Well, yes, don't disparage the other parent. Don't be under the influence with the child in your presence. Basic things of getting in criminal trouble. But the one that sticks out, I was going to say first, is don't text anything that could be used against you. Text messages are probably the most common exhibit in family court. And they're used, even throughout the proceedings to send to the opposing party or the attorney for the child. Recognize that whatever you say, like criminal proceeding, it could be used against you. So be strategic when you're responding to the other side. I can't tell you how many times I've been in litigation with a client and he's or she is texting things to the other side, which they definitely don't want to be used. And we're in litigation. So just be aware of what you're saying, especially in litigation in text messages.
I completely agree. I often tell my clients, say less. Yes, no, I'm not sure. I'll let you know. Keep it simple. Do not engage in text message wars. It's not going to pan out in any way that will, benefit you. It's going to look like it's just furthering the acrimony between the parties. It's not going to paint you in the light you want with the court. You may feel like you're arguing your point to the other party. In reality, it could make you look like you are the more difficult parent, and that could disrupt your parenting time. So just say less, be as civil as possible. And also don't discuss the case with the child.
Yes.
Even as children, age, they become teenagers. We see 14, 15, 16-year-olds in some of our cases, and you still want to not involve them in this. It's for the grown-ups, it's for the parents. They are still children, and exposing them to the litigation is not in their best interest. That's the court's position, and it will be cited in a decision if you don't follow that. So you want to make sure that you're really shielding your child from the litigation. And it's often, we hear from clients that the other party is not doing that. They're disparaging me. They are, discussing this with the child. That is a very simple way to get your violation petition in court and to modify parenting time. These are such easy rules to follow. You don't want to make the mistake of breaking them.
And the attorney for the child or the children will, they hate that. If they believe that the child is learning about the court proceedings, even as simple as, oh, mom has court today against daddy or something, they don't like that at all. They don't want the child to know. They obviously the child or the children, they're going to know something's going on because they have an attorney. But outside of that, they really shouldn't know what's going on in court. Or where the parties are even at in court. So discussions like that should never be had with the child.
Absolutely. Okay, we have a number of questions here, and I'm just going to make this box a little bit bigger because some of them are a little long. And if it's something specific to a case, we may not be able to answer it, but if it is a general question, we will definitely address it right now. Okay, so someone brought up when would a GAL be considered biased? That's tough to say. It would really depend on the facts and circumstances of your particular situation. How can we make sure one parent isn't listening if done on Zoom? You're supposed to give the child privacy when they're speaking with their attorney. If that's not done, well, I'll tell you one thing. These attorneys for the children, they are experienced. They know if a child is being coached. They know if someone else is in the room. They're going to be able to filter out that information. And so you are going to have to trust them a bit and trust the system a little bit, because there's no way you can absolutely know for sure. I can only say to my own clients, don't do this, and hope that other attorneys have also done the same. The attorney for the child will speak to the children as they can. So whoever's parents schedules the appointment, or if they schedule it first or on their parenting time, that's not in itself bias. If you feel like you would like them to speak to the child on your parenting time, just ask them to do that. I've yet to have an attorney for the child tell me no. They don't want to appear biased. They want to appear as if they're just representing their client. If you feel like a child's demeanor might be different, then you can go ahead and simply ask them to speak to them on your time, and then they'll make that decision as to whether or not the demeanor was different, and they can, analyze the situation for their client themselves.
They also can meet the child at school. I had a couple of cases where they would go to the school and meet with the child there, which I find is great because it's clearly, there's no bias in there. There's no parent listening in. But a lot of times, it's not because the attorney for the child has an opinion, who's better fit as the parent when they schedule these meetings. It's who has the child when the attorney for the child is available. So if one parent has the majority of the time, likely the meeting with the AFC is going to be during that parent's time. But it's not necessarily an indication on whose side or position the AFC is leaning towards.
Exactly. Okay, I think we've hit all of the AFC questions. We have a question involving the CPS cases, neglect and abuse allegations. And the question is, how often are administrative reviews turned over? Meaning they requested a review for an indicated report, provided their evidence in their letter, and I'm waiting a response. I have no idea if these reviews ever result in changing. Yes, sometimes they do. If you've submitted your request and you're waiting for that administrative review, the time frame is tricky because they are inundated, they are short-staffed, and we are dealing with a government agency. So patience will win out at the end for you, and they will notify you. It just may take some time. And sometimes, yes, it is changed upon administrative review. We don't always have to have that fair hearing. So you can always call and follow up and find out, what the status is on your case, and someone should be able to help you there.
Likely, though, without a hearing, to be overturned, it's a high standard. And I guess it's not a high standard. It's a low standard for them to prove. So it is very difficult just on submission alone to be overturned. Even with a hearing, it's pretty difficult because we're not talking about beyond a reasonable doubt standard of proof. So it's not. I wouldn't say it's common, but it definitely has happens.
I think we could probably do an entire webinar on CPS investigations, Sarah and I. So maybe, thank you for bringing that up. Maybe we'll do that for the next one. Briefly touch on relocation. How likely is it? Sarah, you've had a couple of relocation cases come your way this year.
Yes.
How'd you fare on those?
So it's a high standard. And if both parents, the parent that wants to relocate and the parent that's staying in the area, are involved in the child's life, it's hard to get. A lot of times it will resolve in settlement, and if it resolves in settlement, typically the arrangement is, unless it's like within a 2-hour radius, you could drive. A lot of times it's like I had one move into Idaho, so the arrangement is one parent has the child during the school year, and the other parent has the child or the children during breaks, summer, spring, winter, long weekends sort of thing. It is hard. You really have to put up a good case why it's in the best interest of the children to move with you, and why you'll be able to maintain, the children will be able to maintain, and you will encourage a relationship with a non-moving parent. Certain things could be, it's the education's better, or it's a great financial move for the children, and because of it, their life's going to be enriched and be better for everyone as a whole. But it definitely isn't. It's not an easy battle.
I absolutely agree. If anybody is interested in looking it up, the Court of Appeals case is Tropia, and the standards are contained in there, it is what Sarah said, it's the best interest, and it's also the fostering of the relationship with the other parent. So you can't just skip town and leave the other parent behind. You do have to have a plan. And like Sarah said, that can resolve by settlement, which is of course in the best interest of the child, to not be put through the elongated process, which can sometimes cause anxiety for the child. But it is a high standard to meet. If
One
you,
thing, sorry, go ahead.
no, it's okay. Go ahead, Sarah.
One thing to consider though is, if one parent's parenting time is one weekend a month, something along those lines, it's a little bit easier to, ensure the court and the attorney for the children that I'm going to be able to maintain this parenting time or the amount of time throughout a year. But if it's like a shared physical custody arrangement, you really got to have a good case to bring about why moving is good for these kids.
Mm-hmm. We have a question regarding still spinning off of relocation. If the other party can relocate and agree to okay, so it looks like a party had previously agreed to consent to relocation and now they no longer want to. Well, you can't force anyone to agree with you, but you certainly can offer that prior agreement into evidence and make your case based on all of the other standards that have to be met for a relocation.
Leslie and I actually had a case together that had similar facts. And one of the parties was proposing, oh, let's move, to Arizona. And the one party agreed and writing in text message. It was clear that, yes, they're coming up with the ideas. And then 2 days later, she's like, no, I don't want to do that. And the father tried to bring a petition trying to relocate based on this consent. Something like that, that's definitely, people can discuss it and have a change of heart. It's not going to be binding for this relocation.
That's right. A binding settlement agreement, any kind of binding consent has to be, signed, notarized, and ordered by the court. It's that text message or that email or whatever, that conversation is not quite enough for you to then have the permission to remove the child from the state. Okay. We have one more question. Looks like, what can we do about a parent who refuses to comply with certain agreed upon issues such as payment of tuition or reimbursement of health insurance? So that's going to be your petition to enforce or your violation petition. And if it is payment of tuition, if it's financially related, if it's from a judgment of divorce, you want to look at your judgment of divorce to see where your venue is. You may have to bring that action in Supreme Court. More than likely, there's language in your judgment of divorce that allows you to bring that action in family court, and then you can just do that through the support magistrate. Okay. We have one more question. Best way to get evidence in? I feel like judge doesn't read lots of it. Okay, so let's talk about evidence. Anything that you attach to your petition, a judge may consider, but it is hearsay. And so it's not going to be dispositive of a final resolution. If you are at trial, you have to admit things into evidence. You have to follow all of the evidence rules. And hopefully, if you are not in compliance with a particular rule, then there's an exception that you can take advantage of. And all of the evidence that gets submitted at trial becomes part of the record. And that's important because if you do feel like your judge has not read all of your evidence or considered all of the evidence properly, then that record can go up to, on appeal to the third department. Well, here it's the third department. So you want to get the evidence admitted, and you have to do that by either you having firsthand knowledge, having someone else with firsthand knowledge getting it in, or it has to be perhaps a business certification signed so that it meets an exception to the evidence rule. You can't submit things to the court before that trial and expect them to give it any real weight because it's just not properly admitted, and we do have to follow those procedural rules. That's your due process, right? That's your constitutional right, and everyone has that, including the other side. So in order for there to be a fair process, we have to follow the rules of evidence.
For first appearances, I think the question also was asking about, the judge will consider it. It's not something they're just going to disregard if a part of your petition is a police report or a text message. It will carry some weight, especially if you need like a temporary order. But it's not to say that the judge is going to completely believe that what's submitted is authentic or, actually from the other party if it's a text message. But, sometimes I do find, even if you submit a beautiful petition to the judge, either they didn't read it very thoroughly or they forgot, but it does feel like sometimes they haven't completely went through what was submitted. So I can understand if you believe sometimes they don't read everything, especially by the first appearance. So you just kind of have to hone in on the important things at the appearance to make sure they remember or, understand what's going on.
And that's so very true and important. During that first appearance, you're only going to get a limited amount of time to bring up, the most important things to the judge. So if there's something you think was not reviewed thoroughly, then that's your opportunity. But make sure that that's what you want to say because your time is going to be limited.
Right. Got to be strategic what you bring up.
That's right. Okay. I think we got to all of the questions in here that we can answer. If you have any more questions, you're welcome to give us a call, schedule a consultation. Both Sarah and I are available, and we have a whole team of family med attorneys here in our Albany office that would be happy to speak with you. And I think, Sarah, unless you had anything else, I think that's it for us today.
No, thank you for joining.